Welcome. Welcome to Massey Dialogues. My name is Nathalie Desrosiers, and I'm the principal of Massey College. It's my great privilege to welcome you here for another episode in our series on Massey Dialogues, where today we're going to approach the subject of anti-Black racism and the criminal justice system and cannabis amnesty. But before we do that, let me just acknowledge that Massey College is built on Indigenous lands, the lands of the Huron-Wendat, the Seneca, and it is the treaty land of the Mississaugas of the Credit. It's our great privilege to continue to do our work here, and we want to acknowledge our special duty of stewardship toward this land. So today is a great subject, one that is dear to my heart and kind of compounds and brings together different reflections that we want to have about the state of our criminal justice system and the way in which cannabis amnesty has to be understood in its larger context. So without further ado, I'm going to pass the mic to the chair of the governing board of Massey College, an expert in policing in Canada and race issues, Akwasi Owusu-Bempah. Akwasi.
Principal Desrosiers, thank you very much for the introduction and for the space to be here this afternoon. It is absolutely my pleasure. I'm joined by two guests who I admire very much, and I look forward to the conversation that we are going to have today. So first, Anthony Morgan. Anthony Morgan is a racial justice analyst and strategist. He's an educator and a lawyer, manager of the City of Toronto's Confronting Anti-Black Racism Unit, which is responsible for implementing the city's anti-racism action plan. Prior to joining the city, Anthony was an associate at Falconer's LLP, specializing in areas of civil and constitutional as well as criminal state accountability litigation. He has a special interest in anti-racist human rights advocacy, and particularly anti-Black racism. He's appeared at the Supreme Court of Canada, represented the interests of African Canadians before the United Nations Human Rights Treaty bodies. He's a frequent legal, social, and political affairs commentator on issues around race, racism, critical multiculturalism, and critical race theory in Canada. In addition to all of these things that he has done, he is completing a master's in international human rights law at the University of Oxford at the moment. Thank you for being with us, Anthony.
Thanks so much for having me.
Absolutely, our pleasure. Our second guest, Annamaria Enenajor, is committed to community service and is an outspoken public advocate for evidence-based and compassionate criminal justice reform. She's the founder and executive director of the Campaign for Cannabis Amnesty. She sits on the board of directors for the Open Democracy Project. She's also a partner at Ruby Schiller Enenajor Di Giuseppe Barristers, where she practices criminal defense, regulatory, constitutional law, and civil law, and where those intersect with state accountability. She's also argued in front of all levels of court in Ontario and before the Supreme Court of Canada. Prior to practicing in Canada, she was a litigator in New York, where she received accolades and awards for her pro bono work in the areas of civil and human rights as well. And Maria also clerked at the Supreme Court of Canada prior to going into practice herself. So Anthony, Annamaria, it is absolutely a pleasure to be with you and to have this conversation. We've got some great minds here, and I'm sure the audience is interested to hear about our discussions on anti-racism, criminal justice, and cannabis amnesty. I want to start by setting the stage for our discussion about Cannabis Amnesty, and we'll get into exactly what Cannabis Amnesty, not only the organization, but as an idea, as a policy, as a social justice practice is. But I want to understand how cannabis features in your human rights, your anti-racism, and your criminal justice-centered work. Annamaria, if I can start with you, please.
Sorry, you cut out there for a second. I didn't hear the first part of your question.
How does cannabis feature in your human rights, your anti-racism, and your criminal justice-centered work?
Thank you. I think cannabis is a very interesting litmus test for the status of anti-Black racism in the Canadian criminal justice system. The reason is because we've known for years that there is a disproportionate prosecution and overrepresentation of African Canadians and Indigenous Canadians in cannabis prosecutions. We've known that for decades. And what that means is either one of two things. One is that Black Canadians and Indigenous Canadians are just committing more of these crimes, or the second is that there is something profoundly unjust going on in the enforcement of these crimes. And when it comes to cannabis offenses, what we're able to determine with certainty is that as a result of the nature of this kind of offense, we've understood, or we've come to understand, that it is broadly committed across the spectrum by all groups of people. It's committed by white Canadians, by Black Canadians, by Indigenous Canadians, by South Asian Canadians, Asian Canadians. Canadians consume cannabis. They commit the offense of possession of cannabis in equal proportions. However, when we look at who is punished for that offense, then we start to hear the real story about how racial discrimination plays into the choice to prosecute, the choice to release on bail, the choice to go after certain people for committing an offense that is very broadly committed. And so when we look at what cannabis tells us, cannabis crimes and cannabis prosecution tells us, what it tells us is that this is an activity that Canadians across the board equally participate in, but that only certain groups are punished for it. And that forces us to ask the question, why does that disparity exist? Because it's something that we can empirically demonstrate. And part of the interest that I have in this work comes from looking at the specific aspects within the criminal justice system that allow for that discrimination to infiltrate in decisions by police, by prosecutors, by judges. And so what I like to look at is elements within the criminal justice system that allow for the exercise of discretion, that allow for individuals, that allow for actors within the criminal justice system to make decisions that then in the aggregate result in the overrepresentation of Black and Indigenous Canadians in the prosecution of cannabis related offenses.
Thank you. And I'm certainly going to follow up on that point about discretion in just a moment, because I think it's an extremely important one. Anthony, if I can ask you the same thing, you've engaged in a variety of different forms of work around criminal justice, of course. I'm quite familiar with your professional history and your advocacy work, but also kind of more general human rights and anti-racism work. Why is cannabis so important to the work that you've done, or how is it featured in the work that you've done, or the impact of cannabis and cannabis laws on the lives of people that you're interested in and concerned about?
Sure. So thank you for the question. In the work that I do, one of the things that I aim to try to support is increased critical awareness of the histories and experiences of people of African descent within Canada. And if we're thinking seriously and honestly about the ways in which Black people have been represented or misrepresented within Canadian history, overwhelmingly that representation has come in the form of stereotypes, prejudice, ideas, and what have largely been destructive narratives about who Black people are, their predispositions to be violent or hypersexual or unfit parents. And for the purpose of this conversation, weed smokers or the perception that we are as Black communities the ones who are the primary users, or in other communities don't use the way Black people are. And of course, we know that this is a stereotype that affixes most, especially towards people who are Jamaican or perceived to be Jamaican, but it goes across the board in terms of people of African descent being labeled with this particular stereotype. So in terms of the work that I do, a lot of the work that I've done inside and outside the city. And of course, I'm speaking in my personal capacity. I'm looking at the different advocacy work I've been able to do as a lawyer as well, has largely been focused on helping to unpack the histories and impacts of these stereotypes and the ways in which they have led to some of what Annamaria has already effectively spoken to, is the disproportionate enforcement of cannabis laws against Black people, because the running stereotype within our collective psyche, whether or not we recognize it, so consciously or unconsciously, is that Black people are the ones who are smoking weed or engaging in other forms of drug use or drug distribution in ways that other communities certainly are not. And so that unfortunately, that perception, that stereotype ends up driving enforcement decisions about where officers are deployed and where they're not. And so the work that I've done is, and I continue to do, is try to help raise critical consciousness within the Canadian public psyche around the perniciousness of these stereotypes, and make sure that we can all identify, recognize, and name them, so that we are checking not just our biases, but we're checking our activities to make sure that we are operating, when we're talking about participating in systems of governance or just social and civic life, we are not reifying or reinforcing negative ideas, stereotypes, or reflecting negative ideas or stereotypes about Black people, one of which being this overuse of Black people overusing cannabis, which is also an invention meant to support the criminalization and further marginalization of Black people, not just in the States, but within Canada as well.
Thank you for that. And I think that invention piece is super critical, especially going back to what Annamaria's just said about like similar rates of use across different racial groups, right? Like when you look at Canada, when you look at the United States and other jurisdictions, people use cannabis as they do other drugs at relatively similar rates, irrespective of their race. Yet we know, based on differential enforcement action, that not everyone's targeted for those. And so there are, of course, serious consequences. And I want to talk about those consequences in a moment to that targeting. Coming back to something that you touched upon, though, Annamaria, I think it is crucial here to identify not only the fact that people use cannabis at relatively similar rates as they did before legalization, and that enforcement of the laws were unequal with respect to who was being policed. But can we talk a little more about the exercise of discretion and where those key discretionary points are, and what the consequence of discrimination at those discretionary points are as you move through the system, how that discrimination can have a confounding effect?
Yeah, absolutely. I think the first stage is what Anthony alluded to, which is the decision to deploy policing resources in certain neighborhoods over others. If you have more police officers that surveil certain communities at a greater degree than other communities, they're more likely to find something, irrespective of the rate at which something is being done in those communities versus others. If a police officer is ever walking around Forest Hill, he's never going to find someone smoking weed in Forest Hill. But if he's walking around constantly patrolling, doing community policing in Jane and Finch area, he's more likely to encounter somebody that is smoking weed there. And then, of course, there's the decision, well, what to do once you've found somebody who is, on the face of it, committing what you believe to be an unlawful act. Police have a great degree of discretion when it comes to low-level offenses like possession of cannabis, which allows them to engage with the individual, make a judgment call about whether they need to confiscate the contraband and let the person go on their way, or bring the force of the criminal justice system down on that person. And a lot of that decision revolves around whether the police believe that this person is a threat, whether they believe or perceive this person and the community that they come from as a criminal and deserving of being brought into the criminal justice system or not. A lot of times when you see the exercise of discretion for low-level offenses, it's based on the notion that certain people deserve a second chance and other people should be caught even if their actions are relatively harmless to society because they are criminals. And so what that results in, based on the stereotypes that Anthony's talked about, is the greater exercise of mercy for some people and the discretion to release and not to bring somebody within the criminal justice system, versus the decision that this person needs to be taught a lesson. And that's where you have sort of the second. So the first was the deployment of resources, and now you have in the encounter the second exercise of discretion. And what that means is that there are certain people from certain communities that are more likely to be found to find themselves within or in front of the criminal justice system and in front of courts and facing prosecution. And then once they get to courts, there are decisions, discretionary decisions that exist along the way that determine the outcome of the scenario that they find themselves in. There are decisions around whether or not the individual should be released from the station, should be held for bail, should have onerous conditions on their release. And those factors are all discretionary and depend on how equipped the person is to advocate for themselves, but also the intuition and disposition of the prosecutors who are in charge of that and their sense of whether that person is a danger to society or not. And again, that decision can often be based on stereotypes and incorrect perceptions of Black people as more likely to be drug dealers or more likely to be violent. And so in some of the cases that I've done where I have clients who are white and who are Black and who are facing the identical set of charges, one could be characterized as a dangerous criminal and the other can be characterized simply as somebody who made a mistake. So that characterization plays on or ultimately determines whether that person is released at the bail stage. And whether a person is released at the bail stage has a huge impact on whether or not or how effectively they are able to fight for their innocence at the trial stage, whether they have a hope for recovering their life as it was before. Often when people are detained and are in precarious situations, they lose their employment, they lose their housing, they're unable to pay their bills. So it compounds this disenfranchisement that exists in society, and particularly and nefariously impacts Black Canadians.
And so this disadvantage in terms of the exercise of discretion goes well beyond cannabis itself, right? And, it's important to note, and I think many people are perhaps listening now or later on and would say, well, cannabis is now legal. And part of the reason that we need, and we'll talk about very shortly, Cannabis Amnesty specifically, is because of the history of unequal enforcement and the impact that has had, right? And so, Anthony, perhaps I'll go to you briefly just before coming back to Annamaria. When we think about the unequal enforcement of laws generally, but especially around cannabis, like why is it important, or what are the impacts that disproportionate cannabis enforcement have had on Black people? So what are the consequences of their criminalization as it relates to cannabis?
Yeah, so there are cascading impacts in so many different ways. But if we look at the over-incarceration of Black people, noting that Black people, the last numbers that I'm aware of, there may be updated numbers, but Black people represent some 3.5% of Canada's overall population, but almost 10% of Canada's federal prison population. And among young people specifically, Black folks within Ontario are 4 times overrepresented in terms of what they represent in the general population as it relates to the rate of incarceration within Ontario. And so what it leads to is this kind of overrepresentation of Black people within the criminal justice system. But then, of course, as Annamaria was flagging, that also has dramatic impacts on the livelihood and well-being of Black communities. And so often we look at instances of child poverty and poverty more generally, and underemployment and unemployment among Black communities. And too rarely do we make the connection between the over-enforcement of things like cannabis laws and other other laws that are essentially used to support a disproportionate targeting of Black people. And so it impacts the economic well-being and viability of Black communities, which of course then impacts the ability for members of Black communities to support future generations, to provide the kind of base support so that young people from Black communities can play viable and healthy roles in the development of our communities and economies. And so it has sort of this snowball effect when we use cannabis in these kinds of ways. And we can't name and speak to this without uh, talking about the war on drugs. And so while it is certainly a legal question when we look at anti-Black racism, cannabis amnesty, and the criminal justice system, to an extent it's a legal question, but that's somewhat of that's only one part of the problem. When we really look at the histories in the 1980s, when we had the Reagan administration explicitly drive the increase of incarceration of Black people through the languaging of the war on drugs and initiatives framed around this war on drugs, they essentially, that government essentially created a kind of boogeyman. And sadly, that boogeyman was often, not exclusively, but often Black. And so within the American context, uh, there are these projections of media into the public realm, and these notions and stereotypes again being reinforced of Black people being heavy drug users and being a threat to the American way of life and well-being, and ultimately hindering the progress of America. Now, why that's important, I know we're having a conversation with primarily a Canadian audience, but what's really important to take serious is how much the American media machine is taken in within the Canadian context. And so often we find that many within Canada are overexposed to American imagery and symbols and storylines and narratives. And so it's not that the issue of anti-Blackness within the collective public psyche didn't just stay within the United States, but it ended up being ingested within Canada. And then further, that supported what was then in the 1980s, um, the federal government under Brian Mulroney also started to adopt heavy measures that ended up disproportionately criminalizing Black people. And if you see the rates of incarceration that alarmingly skyrocketed during that period, and you do the research, you end up seeing that these were actually political decisions about who society would essentially scapegoat as the threat to our economic progress, because we know the 80s was a time of economic challenges and those hiccups, and we've seen this historically too, often get blamed on racialized people, minority communities, communities that are already othered. And so Black communities through the war on drugs were used as that scapegoat. And so what ended up happening is a drive towards changing laws, policies, practices, and criminal justice enforcement that drove the over incarceration of Black people. And cannabis was a key part of that. Now, within the Canadian context specifically, this also got further augmented because the highest rate of immigration primarily among the Black diaspora was Jamaican people. And so all Black people within the Canadian context more or less got framed as being Jamaicans or potential Jamaicans. And it's not necessarily about their nationality, it's about what Jamaicanness represented within the Canadian psyche. And so it was guns and it was drugs. And those guns were used to help support and push drugs, and that drug being cannabis. And so all of these pieces were playing a part and have played a part in shaping criminal justice policy, but also social attitudes and ideas about Black people, and especially young people, and their use and what is projected as their abuse of cannabis in relation to the broader population.
Thank you, Anthony. I appreciate the historical contextualization there, but also the links to the United States, right? I think, when we talk about a war on drugs, when we talk about drug prohibition, we too often think about this as an American phenomenon, negating the fact that, we had under Brian Mulroney this war on drugs, and that war on drugs did bring in vast numbers of Black people into our criminal justice system. And you've alluded to some of the statistics. When you look at GTA area correctional facilities and the increase in the rates of incarceration following Mulrooney's announcement of a war on drugs here in Canada, we see those rates rise across the board, but for Black people, infinitely more than for white people. So they quite literally several thousand times across some of these institutions. And I think that's, extremely important for us to consider. Annamaria, I want to go to you then. So we've, acknowledged that our drug laws have been enforced disproportionately against Black and Indigenous people. We've talked a little bit about what some of the consequences are. What is Cannabis Amnesty, both, as a policy, but I also want to hear about the organization.
So the notion or the idea behind Cannabis Amnesty is one where, as countries become more enlightened about how to appropriately govern the use of substances like cannabis that have been criminalized, and countries like Canada shift from a criminalization or a criminal approach to cannabis, from that to a public health approach and a regulatory one. Cannabis Amnesty is the idea and the notion that the legalization of cannabis can be used to undo the harms caused by prohibition. And so Cannabis Amnesty as an organization started really when the government tabled Bill C-45, and disappointingly, there was absolutely no mention within that piece of legislation that's purported to completely revolutionize the way Canada approaches cannabis governance. There's no mention of the very difficult and ugly history of the way in which cannabis criminalization impacted some of Canada's most vulnerable communities. So Cannabis Amnesty started as a response to the absence of any government action towards fulfilling that broader amnesty objective, as was done in other jurisdictions. In the United States, Cannabis Amnesty took many forms. It took the form of the automatic expungement of criminal records for those who were convicted of offenses that are no longer illegal. It also took the form of creating preferential economic instruments that gave preferential treatment to those who came from communities that were disproportionately policed and harmed, and as a result harmed by cannabis prohibition, that were targeted and attacked by the war on drugs, and that suffered as a result. And as Anthony so eloquently mentioned, there's a cascading effect from that which impacts the economic viability of these communities. And Cannabis Amnesty is the recognition that now that we've decided to create a legal industry which is wealth producing, it is incumbent on us as a society to leverage that wealth that's been created and reinvest it in these communities that have sacrificed so much and were harmed so deeply by cannabis prohibition.
I'd like to open up to both of you and ask why you think the government was slow to move with respect to Cannabis Amnesty. Why did we not see these measures in the government's first iteration of cannabis legalization? And this is open to either of you. Annamaria, I don't know if you want to start, and we can go to Anthony.
Sure. So the step towards the legalization of cannabis was politically a revolutionary one. It was one, and governments don't like to be revolutionary unless they're in the middle of a revolution. They worry about re-election. They worry about the perception, especially when it comes to criminal justice, that they are soft on crime. All governments want to appear as if they fight bad guys and look out for the vulnerable. And it was a big risk that the Trudeau government took in stepping up and implementing Bill C-45, theoretically, the theory towards the theory around the legalization of cannabis. And Canada was the first the first nation or the second nation, sorry, I think Uruguay is the first nation to do this. And as a result of that, I think the government was very gun shy in terms of what it would do with that legislation. And they wanted to make sure that they maintained a law and order appearance and semblance so that they have some sort of immunity against their critics. So I think that amnesty, the notion of wiping out criminal records and reinvesting in communities that have been criminalized, was probably polled by the government, and just as a political decision, it was something that the government said, we've got to delay because we've got to make our initial decision a mainstream one. So I think it was a purely political decision, and we see the government inching towards amnesty-like measures, but there's a long way to go. I think we'll ultimately get there, and there's an openness and an appetite for that. But I think that it was too much too soon for them to do politically. I think ethically and morally, I think it was the right thing to do, and I advocated for it from the beginning. But I understand their political reluctance as sort of a pragmatist.
Yeah,
Anthony, your thoughts?
I echo the great comment made by Annamaria in terms of providing that context, in terms of sort of the political capital had come at a particular kind of time, but not enough political capital to truly push things in the direction that would more meaningfully undo some of the decades of harm that have been caused by prohibition. And so when I think about why it took so long, I think there are a number of different reasons. But for the purposes of this, what I think is worth pointing out is some of the context of organizing and advocacy that had been created around that time. Again, I don't think it's only because of what was happening in the States, but we have to, I think, look at the years just before, leading up to the Canada decision to make Canada's or the Canadian government's decision to change course in this respect. And what I'm referring to here more generally is what some refer to as kind of the first wave of Black Lives Matter advocacy. So if we're looking from the verdict of George Zimmerman in 2013 and how Black Lives Matter emerged on the scene from 2013, at that time and for a number of years, speaking to the criminalization of Black people, anti-Black racism, the disproportionate shooting and killing of Black folks, there was a kind of way in which the public, largely within America, but not exclusively within America, because again, how much American media that we ingest within the Canadian context, where it was becoming recognized, and the Obama administration itself started to realize that it couldn't hold the line on the ways in which drug enforcement had been going up to that point, because of the degree of advocacy that had been pushed, not exclusively by Black Lives Matter, but there was a general movement that brought in other voices, where it was increasingly untenable to maintain the rates of over incarceration that were being generated through disproportionate cannabis enforcement. And how that impacted Canada is that Canada also had its own wave of Black Lives Matter advocacy and organizing, and different members within Black communities were not just protesting, as historically been the case, but also taking on positions of authority and providing, you might say, somewhat problematic, but coming from a different position, not just being scholars or advocates, but being lawyers, being judges, coming from different walks of life, being educators and teachers, saying this has a dramatically negative impact and has had a dramatically negative impact on Black communities. Something must be done. And so I think the Canadian government was hearing these voices in different ways at a different time in the context of this sort of this climate of protest against anti-Black racism. And I think that plays a part in that shift, but still, because it hadn't developed earlier, I think is why, or hadn't developed in the ways in which it's developed since you might say the first wave of Black Lives Matter organizing, and now we might say there's a second wave of that movement that has come after the killing of George Floyd.
Indeed, seismic shifts with respect to our understanding of the impact of anti-Black racism and racism generally on the lives of people who are affected by it. But also, to your point, Anthony, around the failures of criminal justice approaches to deal with social problems, right? Like when you look south of the border, you've got even the Koch brothers funding kind of criminal justice reform initiatives around this same time. So I want to talk about what we have in terms of amnesty specifically then here, to see where we need to go further. So Annamaria, if you could just like, give a bit of an explainer. When we talk about the actual clearing of records or partial clearing of records in relation to what the government has done, what are we talking about? What amnesty has the government provided to people who were convicted of cannabis-related crimes previously, prior to legalization?
Okay, so this is a web of legislation I'm going to try to outline, so stay with me. It might get confusing because I think it needs some historical context. So Canada used to have a pardon regime. Under the Harper government, it was changed to a record suspension regime. Now, that name was intentionally chosen because it meant to convey that you don't really get to clear your record. You kind of hold it in abeyance, and if you're good enough, it'll never come back and haunt you. But it's still kind of there. What the record suspension regime is one that we have currently for all offenses. It allows people who have been convicted of a more serious or indictable offense to make an application to the Parole Board of Canada after 10 years to have their records suspended. And people who have a less serious offense, so offenses that are preceded, where prosecution is preceded through summary conviction, they are allowed to make that application after 5 years. They don't have to wait 10 years. But essentially, even if you win that application, if your application gets accepted, what it does is it removes your criminal record from one database and puts it aside to another database. And the current sort of general record suspension regime, the name hasn't changed since the Harper years. What is as a result of that is that there can be scenarios where your record comes back if you've committed a further offense, or if there are certain sort of statutory criteria are met. Now, what the Canadian government did in 2016, 2017 was devise a parallel procedure called an expungement regime. An expungement regime is actually a regime where your record is deleted. It is wiped out clean. No one can find it. The government doesn't have it stashed away in a secret, bunker chamber somewhere. It's not in the police database. It can never be found. But the government has self-imposed or imposed on itself is a restriction that expungements should only be available for historically unjust crimes. And what they've defined as historically unjust crimes are essentially there's only one to date, which is the criminalization of homosexual acts. So what the government has said, and rightly so, is that those acts, those offenses, which have been off the criminal books for decades now, they were in and of themselves historically unjust and discriminatory against homosexual people and people from LGBT groups. And as a result of that, we are going to expunge any convictions for homosexual sex that exist in our criminal records. When it came to cannabis, the government said we are going to remove the simple possession of cannabis from our books. It's no longer going to be a criminal offense. We don't think it's worth prosecuting. But it's not a historically unjust crime. That's how the government's characterized it. They've recognized that that the unequal enforcement of these laws have had a disproportionate impact on racialized and Indigenous communities. But they've said that the offenses in and of themselves are historically unjust. I take great issue with that, and I've always argued that cannabis prosecutions are perhaps offenses that should come under the umbrella of expungements. When we've advocated at Cannabis Amnesty for what amnesty should look like in order to be fair and just and equitable, we've identified 3 features. One is that they must be free. The record suspension regime, it costs just the application form, just the application fee, upwards of $600. So we say that that's unjust, it's unfair, it's a barrier to access, and it should be removed. So it must be free. It must be permanent. So this is where we get into contested territory with the government. We think that expungements, which is a permanent solution to record deletion, should be the way in which these kinds of applications are handled. And the government has said, no, we're not going to use expungements for that. We're going to use record suspensions, which is, again, taking of the records and aggregating them and putting them in a separate government filing cabinet, where certain law enforcement should not be able to see them. They shouldn't come up on a vulnerable sectors check, but it could still impact your ability to cross the border, and it could form part of certain law enforcement documentations. And then finally, the third aspect of a true amnesty is that it must be automatic. And this is taken from the example of many United States districts that have automatically just wiped their databases of these offenses. What we currently have is a regime that requires application. So we have these three elements that Cannabis Amnesty was fighting for and lobbying for. And in 2019, the government said, okay, we actually recognize that there is a need to have a special kind of process to delete the records of people who have simple cannabis possession on their criminal records. We're not going to treat them like we're treating everybody else in the in our record suspension regime. We're actually going to do two things to make it easier for them to access these record suspensions. We're going to make it free. So we're going to waive the application fee, the $600 and I think $638 or something like that. We're going to waive that. And we're going to allow them to apply much earlier. So we're going to waive the waiting period of 5 years for simple possession offenses, which are summary conviction offenses. So that was a big step, and that's what the government did with Bill C-93 in 2019. So what the government has done is basically taken one of our suggestions, which is that the true amnesty must be free, and they've implemented that. In terms of the other two suggestions, we don't see any movement on the front of trying to persuade the government that pardons are not enough, we need expungement. They've been sort of very much consistent in their messaging that expungement is reserved only for this one category of crime called historically unjust crimes. And the second being that it must be automatic. We're starting to see some recognition that this is actually the way to go. The media has reported that over the past 2 or 3 years since Bill C-93 has come into effect, and we have the specific legislation that was supposed to make it simpler for people with simple cannabis possession to access record suspensions. Of an estimated 10,000 people that qualified for this kind of pardon, this kind of record suspension, we've only seen approximately 480 some odd successful pardons be granted. And so what the government has come to realize is that there's something about this process, the application process, that remains complex, it remains inaccessible. It doesn't do what it's supposed to do, which is make it easy for people with these criminal records for things that are no longer illegal to move on with their lives. And so we've heard some mutterings come out of public safety. Minister Mendocino has talked about looking at implementing some kind of automatic mechanism for people with certain criminal records. And I think that's part of a broader package to reform the pardon system in Canada, because it's not just cannabis offenses that have demonstrated how ineffective the pardon system is in Canada. It's other offenses as well. So I think we'll see a shift, and there was a press release in November, December around this, but not much movement has happened on this front since then. I think a lot of it has to do with the surge of Omicron and the government's focus on that, as well as the occupation in Ottawa. So they've got serious, bigger issues, serious issues that they're
Things have
dealing
been a
with
little busy in
currently.
Ottawa.
Yeah, things have been
over the
rough in
last few
Ottawa,
weeks.
and
Yeah.
and so I think that's something that we can look forward to, but we can look forward to the government trying to move towards automatic record suspensions at this point.
Okay. So I just want to kind of recap some of the ground we've covered here. We have these laws that are rooted in kind of a racist and discriminatory past that have had a disproportionately negative impact on Black and Indigenous peoples. Those peoples were not fully considered in the development of our cannabis laws, and it was only as a result of the advocacy of groups like Cannabis Amnesty and others that we got the record suspension system that we have. That record suspension system itself has been called an abject failure. You discuss some statistics. Less than 500 of the estimated 10,000 people have actually successfully received a record suspension. Anthony, before I open things up to everyone, we've had cursory conversations about the Black Justice Strategy that the federal government has just announced. In addition to providing just some context about what is needed to advance racial equity and justice in the context of our justice system specifically, are there any lessons that can be learned from the failures of our government's attempt at some kind of redress here in moving forward?
Yeah, I think the inefficiency of half measures has become obvious, where the government is actually creating more of a challenge for itself by not being as far-reaching as they could be or should be as it relates to addressing these long-standing issues. And so, to the extent that one can say, I think there's a lesson in the importance of depoliticizing this issue. Although, of course, it started as like as I mentioned, a very political gesture in terms of the war on drugs policies and programs being adopted in the States and in Canada to support more aggressive enforcement. We need to recognize it as a public health crisis that's been created, and look at it as a look at changing direction in a way that is more reparative. Reparative by taking stock of the harms that have been caused, acknowledging and recognizing that, and then adopting policies and programs, for instance, supporting enhanced educational supports for Black communities who've been ravaged by this war on drugs, looking at housing disparities that have been created because of the over-incarceration and over-policing of Black folks. So again, the impact that has had on the economic viability of Black communities needs to be accounted for, and I think this is a way, in part, to do it. So looking at things like education, housing, but also employment, thinking about how we can create programs and initiatives that help make sure that talented, skilled, qualified Black people are getting the jobs that they've historically been denied or haven't had the opportunity to get because of the ways in which the socialization of these stereotypes have led to suspicion around individuals' ability to do a job. Now, that might sound far-reaching, but if we think about, for instance, if anybody is from Black communities or has a relationship with Black folks, literally the idea of showing up to work or an interview with dreadlocks or deciding to style your hair in dreadlocks would be something that overwhelmingly many Black folks would say, I can't do that. They will think I am a drug user. Or I showed up to the interview like this. I don't know why I didn't get the role, but I suspect it has something to do with how I presented. And what that's related to is, of course, not just dreadlocks themselves, but dreadlocks in the association, again, with crime, violence, and specifically with the use of cannabis. And so consciously and unconsciously, those are stereotypes that impact many folks. And so doing justice and changing direction means accounting for that, but also looking at ways in which we can better support public health. So also having a public health approach by looking at some of what has existed as a kind of social despair that sometimes has set in among too many Black communities because of the over policing, the marginalization, which then can create conditions where, just to relieve pain and stress, cannabis has been used by a number of young people and just a number of people within communities. And so changing course going forward means accounting for all of that: education, employment, housing, healthcare, and a number of other spaces need to have a reparatory justice framework applied to them. And the Black Canadians Justice Strategy, I think, is an opportunity to do that. But that opportunity, I think, will only be taken advantage of if we have critical conversations like this and we raise the collective consciousness and voices of members of the public to say this is the right thing to do and it's well overdue.
I teach a couple of classes at the University of Toronto on inequality and criminal justice. And one of the things that I make very clear to my students is that we're not going to be able to resolve the issues that lead to the overrepresentation of Black and Indigenous people in our justice system if we focus on the justice system alone. And I think, Anthony, your comments about addressing education, vibrancy in communities, health, etc., gets exactly to that point. I want to open things up now. We have just a few minutes left, so I'd like to take some questions from the audience if they're there. So here we have, is the problem for amnesty is that it will target specific offenses. If it targets only possession, as you say, Black persons are more likely to be charged with possession, plus resisting arrest, possession and intent to traffic. What are you recommending? Okay, so Annamaria, as it stands at the moment, what's captured by the government's regime? What's captured by proposed regimes, even beyond cannabis, and what should be there, and why is this important?
So I think Natalie poses an excellent question, which is the reality that the majority of people currently with simple cannabis possession on their records have simple cannabis possession plus other offenses. So the specific regime designed to address those who have only simple cannabis possession on their records, which is Bill C-93, that regime only applies to approximately 10,000 people, whereas it is estimated that upwards of 500,000 people actually have cannabis possession offenses on their records, but they wouldn't qualify for the C-93 regime because the C-93 regime requires them to have simple possession and only simple possession on their records. So the expedited regime is one vehicle through which people with cannabis possessions can apply for a pardon. However, we still have the general pardon regime, which is expensive, complex, and requires you to wait for a significant period of time before you're able to apply for it. What we at Cannabis Amnesty have decided to do is to go beyond the beyond C-93 in our attempt to provide services to those individuals who are concerned or who have cannabis convictions on their records but do not qualify for Bill C-93 because of the presence of other offenses on their criminal records. Now, I think that what the existence of a dual regime does is it kind of communicates that people with simple cannabis possession on their records deserve an easy, quick, simple, cheap regime, and everybody else should have to go through the burden of having a lengthy application that is costly and expensive. And we've said, understanding the way that understanding the way that prosecutions work and enforcement works. This is not just a cannabis issue. This is the disproportionate representation of Black and Indigenous Canadians and Canadians from vulnerable and marginalized communities. That disproportionate representation goes beyond cannabis. So we want to challenge that division that exists between simple possession records and simple possession cannabis records and other records, and saying that everybody is deserving of compassion and mercy and of a second chance to the extent that they qualify for it under the current pardon regime. I think one of the things that struck me so much when I started practicing criminal defense was the way in which so many of the people that come before the courts are from vulnerable and marginalized communities, not just racialized, but people who have experienced abuse, physical and sexual, experience addiction, and experience mental health issues. And those people are also over-criminalized, over-arrested, and as a result have multiple entries on their criminal records. And so I think it's really important for us to flag the limitations of Bill C-93, but instead of leaning into it, I think we need to challenge it and say that we need to expand the way in which we, the population for which we feel compassion and we feel what should be extended a helping hand.
So maybe I'll get us to finish things off here. Senator Kim Pate has proposed criminal records simply expiring. There are, arguments that are advanced that after a certain duration, people's criminal records should simply vanish. What do you folks think of that?
Yeah, I don't think it warrants a long conversation. If we look at the ways in which people have had their lives so seriously circumscribed because of that moment in time where they were not just they found to have done an act, but were found to have done that act. And if we think about some of the discriminatory ways in which we've talked about enforcement impacting lives, there has to be a balancing of somewhat the arbitrary and perhaps we wouldn't say arbitrary. It's racist in many ways. Racist enforcement has led to these disproportionate impacts, and so I'm not talking about not holding people accountable. I think folks confuse accountability with criminal records, and I still think that there's room for accountability, but it should not include being saddled for extended periods of time with these criminal records, because the data is clear that this is actually not helping individuals contribute more to society or help them support their families better or be able to support the development and unearth their potential and their child and their family or their loved one's potential. Overwhelmingly, it steals that potential. It limits that potential and it limits their ability to contribute to the well-being of collective society.
Thank you. Annamaria, last words here.
So I completely agree with Anthony. I think that the answer is very simple. I think that the only reason why you would maintain these criminal records is because of our human failure that has us that our human failings, sort of as human beings, we tend to desire vengeance upon people who have wronged society, even long after it makes any rational sense. And that is seen by the fact empirically, where if you look at people who have criminal records, the vast overwhelming majority have done one thing and one offense only and are not repeat offenders. The only reason to continue to track people is if you believe that it somehow protects society. And what we've seen empirically is that it does the opposite. It damages society. It ruins people's ability to reintegrate into society. It causes lifelong fear, stress, anxiety, and that then transfers to generations, future generations, and has a really devastating impact on communities' abilities and people's ability to be resilient and to be contributing members of society. So we think that we are protecting people by keeping these records, but in fact, what we're doing is we are limiting the ability of people to make the kind of contributions to society that we value and that we demand that they do make.
Thank you. I think when we look at, Western modes of justice, they seek to stigmatize and to ostracize, right? They quite literally push people to the margins or beyond the margins of society. And we've seen criminal justice practices and our modes of punishment evolve over time and become less brutal and more humane. And it's certainly my hopes that we will incorporate more from Indigenous modes of justice, which seek to be, as Anthony's talked about before, more reparative, more restorative, and that over time we will do exactly that, rather than pushing people out of society for a wrongdoing, that we will seek to repair the harms to them and to society so that they can move on and be full and contributing members to our communities and to our societies in a way that they're not now. Panelists, guests, Annamaria, Anthony, I want to say thank you very much for joining me in conversation this afternoon. It's It's always a pleasure. I appreciate any time I get the chance to talk to you both, and appreciate the work that you do. Thank you, Natalie, for the invitation to moderate this panel, and to our guests for being here and to listening to us engage in these conversations. Thank you.